Hello, my name is Matt Bechtel. I'm an attorney with the Green Law Group. Today we're going to be talking about the HR best practices for contractors. Next slide. So first, we'd like to thank our sponsors for supporting us in these webinars that we're doing. The sponsors are listed on your screen. Now, before we get started, as always, I have to give a warning, like lawyers always do. Nothing we hear today should be construed as legal advice. While we do give you accurate information to the best, to the best of our ability possible, the reality is that the law is dependent on facts, and every factual scenario is different. So today we're going to be talking about a general overview of various legal issues. But if you have any specific questions or specific issues, you should consult legal counsel before relying on anything that you do here. Now, the Green Law Group is a law firm that started focused on the construction industry. We handle all aspects of construction and business operations for construction and contractor clients. Most of our clients are contractors in various trades. We handle construction dispute issues. We also handle licensing issues, employment issues, general HR issues, and anything dealing with contractors. Now, my specialty or my area of focus, I should say, is employment law. That's what most of my experience is in. I spent the first 9 years of my career representing Taft-Hartley trust funds in the construction industry. I represented the IPW NECA trust funds, the pipe trades trust funds, and the operating engineers trust funds. For the last few years, my practice has been focused almost exclusively on employment law matters. Our firm has 7 attorneys currently. One of our partners is actually a general contractor himself, and all of our attorneys work in some aspect in the construction field. Now, today we're going to talk about various issues relating to employment-related issues for contractors. I've broken this presentation down into 3 general categories. First, we're going to talk about just general HR requirements. A disclaimer: there are over 200 labor codes in California. We're not going to address everything today. We've selected issues that tend to be specific to contractors. There will be a question and answer session at the end if you have any more specific questions. So the first thing we're going to talk about is the general HR requirements. Second, we're going to talk about general liability issues. And third, we're going to talk about termination of employment. Most of the time, issues don't arise until you terminate an employee, and that's when all these liability issues we talk about pop up. So first, wage and hour requirements. Now, one issue that I have seen a lot with contractors is minimum wage issues. Now, the general idea of minimum wage is easy to understand. It gets more difficult because there's just too many different minimum wages at play, and many contractors just don't know what it is. For example, there is a federal minimum wage, which for the most part is irrelevant because California's minimum wage is larger. However, there is currently a bill pending that might change that. Then there is California's minimum wage, which is currently $14 an hour for larger employers, $13 an hour for employers with 25 or fewer employees. But then there's local minimum wages that vary by city or county. So for example, in the city of LA, the minimum wage currently is $14.25 an hour for smaller employers, $15 for all other employers, and in July of this year, it'll be $15 for all employers. Now, what comes up a lot is you have, in the construction field, you don't have employees that go to an office every day. They go to different job sites. So which minimum wage do you have to pay? Generally speaking, you have to pay the minimum wage that applies to the location that the employee is working. You don't necessarily have to pay the employee that minimum wage for all hours, just the hours worked in a specific jurisdiction. However, it's often easier just to have a set minimum wage that covers all the work that's being performed. However, there's other issues with minimum wage that pop up as well. For example, in the contract and industry, there's prevailing wage requirements for anybody who works on public works jobs. Prevailing wage essentially is the wages that the unions have negotiated for each trade. It varies depending on what work is being performed. So if you are bidding on prevailing wage jobs, you do have to make sure that you're paying the prevailing wage amount. The purpose of prevailing wage, by the way, is just to ensure that non-union contractors don't have a disadvantage or an advantage over union contractors. Another thing that comes up fairly often and trips up contractors is whether or not they require their employees to use tools. And the reason this is important is California requires that any employee that's required to use their own tools must be paid double minimum wage. So if you're paying your employee the minimum wage, but you're also requiring them to use their own tools, and the end result is you're not paying them the minimum wage and you're opening yourself up to liability. The second issue that we see a lot for contractors, in fact, for every claim that, employment claim that comes to our office, is there's always an allegation of employees not getting their meal or rest periods. Now, generally, the law requires every employee must get at least a 30-minute meal period within the first 5 hours of work. As far as rest periods, the law generally requires that for every 4 hours of work, you get 10 minutes, and the 10 minutes should roughly be in the middle of each 4-hour period. Now, it's important that meal periods are given timely, meaning they must start within the 5th hour, before the end of the 5th hour of work. If you don't provide a meal period or you don't provide it timely, the penalty is 1 hour's worth of pay that you must pay your employees. There's a similar penalty for failure to provide rest periods. Now, there is an exception for the construction industry that applies to rest periods, but not meal periods. And that exception allows an employer to delay the rest period if it's necessary for the trade being worked on. So, for example, if you're a drywalling contractor and you're using spackle that only lasts 20 minutes before it cures, you can delay a rest break and make them finish their work before they take their rest break, and that's not a violation. You still do have to make sure you give them the rest period before the end of their workday as well. The next common issue that comes up is not timely paying all wages due, in particular overtime and double time. Now, generally the law requires that if an employee works over 8 hours, they must be paid time and a half for all hours worked. If they work more than 12 hours, they must be paid double time for all hours that they work. I've seen very often contractors who pay their employees straight time for all the hours worked, and that leaves you open to overtime violations and a bunch of penalties that get attached to it. The next issue that we see a lot is pay stub violations. Now, there's a labor code 226, that basically has 9 requirements that every pay stub must include. If there's anything missing from the pay stubs, you can be open to violations and penalties that can be up to $1,000 per pay period per employee. So it's important that you include everything that's supposed to be on the pay stubs. We'd recommend that you consult an attorney and give a copy of your pay stub and let them see and analyze whether anything is missing from the pay stubs, just to avoid claims of pay stub violations. And it's important to note that a lot of people rely on third-party payroll processors like ADP or Paychex, who they provide the paychecks, they provide the pay stubs, and they assume because these companies are providing them, they're accurate. Oftentimes they are, but we see oftentimes they're not as well. They're missing something. And if they are missing something required by California law, your payroll processor will add it. You just have to make sure you direct them to do it. And the last issue that we're not going to talk about in detail today, but everyone needs to be aware of, is misclassification of employees. There's 2 types of misclassification that can occur. The first misclassification is treating an employee as an independent contractor. Now, as a general matter, and again, we're not going to get into the specifics of this, but generally, if you have an employee who's doing the same, working in the trade that your license is in, it's not possible for them to be an independent contractor under current law. Now, in that situation, you're opening yourself up to a lot of penalties and violations if you pay an employee as an independent contractor. Now, the second type of misclassification that happens a lot is exempt issues. Now, it's legal to pay an employee on a salary basis, but generally, if you pay an employee on a salary basis, you still have to pay them overtime. You still have to track the hours that they've worked, which most employers, when they pay on a salary basis, they do it because they want to avoid all of the hassle of that. Now, in order for an employee to be exempt from overtime, and in order for you to be exempt from keeping track of the hours that your employees work, the employee actually has to meet an exemption. There's 3 general exemptions. There's a few other exemptions. Again, we're not going to go into detail due to time on it, but if you are paying any employees on a salary basis, you should talk to an attorney to verify that you're complying with the law. Now, just a note, public works prevailing wage, if you're going to be doing public works jobs and you haven't done them before, we recommend that you talk to counsel before it, just so you know, before you can be granted or bid on any public works jobs, you do have to register with the Department of Industrial Relations. Employee handbooks. We recommend that all employers have an employee handbook. Now, there's certain pros and cons to it. Now, employee handbooks is basically a book that sets forth all the policies. You'll provide the book at the beginning of employment. It will explain everything from your leave laws and sick sick leave policies to certain disclosures the law requires you to provide. You will also typically provide have any sort of progressive discipline or discipline policies in there. The advantages of employee handbooks is they establish a uniform set of policies that you can rely on, and it limits potential lawsuits from employees. Oftentimes, employees will allege that there was a policy that didn't actually exist. And if you don't have an employee handbook that clearly spells out your policies, it ends up being a he said, she said situation and expensive for an employer to defend, even if they're in the right. By having an employee handbook, the policies are set forth for your employees. They know exactly what's expected of them, and it avoids allegations of discrimination and harassment because you can show that you have a uniform policy and you stick by that uniform policy. Now, some of the cons of an employee handbook is if they're vague or imprecise, it can create disputes where disputes otherwise would not exist. And the most important thing about an employee handbook is management has to know what's in it and abide by it. For example, if you have an employee handbook that has a progressive discipline policy, which is a policy that says if there's performance issues, the first time you get a written warning, the second time you get a verbal warning, second time you get a written warning, then the third time you're terminated, and you don't follow that policy, an employee or an attorney is going to use that against you and say, well, the reason you didn't follow your policy is because you're firing the employee for an unlawful reason. So you want to make sure that when you have the employee handbook, make sure you know what's in it and make sure you follow as the employer. And you can also, of course, hold your employees to it. And if they violate it, that's a good reason to terminate them. Lastly, you're going to make sure that you regularly update your employee handbook. Typically, laws change every year. Not every time does it require a change in the handbook, but when laws do change, you do want to make sure that your policies are consistent and lawful. Now, every employer in California is required to have an illness and injury prevention plan. There's a federal law that requires this. There's also, state Cal OSHA requires that as well. This is particularly important for contractors because injuries are more prevalent in the construction industry than in other industries. Now, we're not going to go into details about what has to be in the plan. We can help you, put together one if you need it. Basically, it's a set of policies that are designed to reduce risk of on-the-job hazards. It is required by law, and you could be prosecuted if you don't have policies and there's a serious injury or illness that could have been prevented by one. Lastly, workers' compensation. This is another requirement that all employers are required to have, but it has particular important consequences for the construction industry if you do not have workers' compensation insurance. Now, all employers are required to have it. If you do not have workers' compensation insurance, you could be deemed a non-licensed contractor, which has many ramifications. So, for example, if you're doing if a client sought rescission of a contract and to recover the amounts owed because you're an unlicensed contractor, even though you had a license, if you let your workers' compensation insurance lapse, you could be deemed non-licensed, and a client could be entitled to all of the amounts they paid you, even though you were otherwise licensed and actually had a CSLB license number. But more generally, and this is not specific to the contracting industry, there's many penalties that attach to failure to have workers' compensation. First off, if you don't have workers' compensation insurance, employees can sue the employer directly for any liability. They may attach the property of the employer to secure any judgment. There is a presumption, it's a rebuttable presumption, but there's a presumption in the law that any injury that was suffered was caused by the negligence of the employer, even if that's not the case. Now, it's important to note that in a typical lawsuit, the plaintiff, or in this case the employee, would have the duty to prove that the employer was negligent before they could recover for an injury based on the employer's negligence. If you don't have workers' compensation, the law reverses that requirement. So the burden then becomes on, there's a presumption that you were negligent as the employer, and it's the employer's job to prove that they were not negligent. The other thing you got to realize is that certain defenses that are normally available in negligence claims are not available if you don't have workers' compensation coverage, including contributory negligence or that the employee assumed the risk of the harm. And lastly, if you don't have workers' compensation coverage, attorney's fees are recoverable, which typically they would not be in a tort claim. So in addition to the amount you found to be liable for the negligence, you can also have to pay a lot more. And in some claims, the attorney's fees can far exceed the actual claim itself. And lastly, I'm not going to go into detail about the posting requirements. There's a bunch of different requirements under both state and federal law of notices that you have to give to your employees. There's the slide on your screen has websites that gives you more information about it. Most employers satisfy this requirement by buying a poster, and there's many companies that provide it, and they provide new ones every year that are compliant with both state and federal law. It's just important for you to know that there are certain notices that you must give to your employees. Typically, it's in a poster you would put in a break room or where the employees normally congregate, and you want to make sure that you abide by those laws. There's certain penalties and ramifications if you don't, and an employee is harmed by them. And just so everyone knows, these slides will be available on our website after this is done, so you can come back and refer to it at any time. Now, a note about undocumented immigrants. I bring this up because it's more common in the construction industry to see undocumented immigrants hired. Although it's unlawful for an undocumented immigrant to work in the United States under federal law, all the protections of California employment law apply to undocumented immigrants. So I've seen often contractors, I don't want to say often, enough to make it a concern that contractors hire undocumented immigrants assuming they're not going to rock the boat. They pay them in cash. they pay them less than minimum wage or less than prevailing wage, and they think it's not going to come back and bite them because they can't legally work in America anyway. That's not the case. If you hire an undocumented immigrant, they have all the same protections as everybody else. They too can sue for unpaid wages, for unpaid minimum wage, and it's just like any other employee. The other thing you got to realize is in California, E-Verify, which if you don't know what that is, there's a federal website and program that allows employers to verify whether or not a person can lawfully work in the United States. In California, generally it's illegal to use the E-Verify program to verify employment eligibility. There are exceptions, when it's required under, federal law for certain federal employment or federal contracts. But absent that, the general rule is you can't use the service to verify whether or not someone can lawfully work in the United States. Now, a couple of years ago, California changed the law and started issuing driver's licenses to undocumented immigrants. Now, the driver's license, identify on them that it doesn't, provide eligibility. It's not proof of eligibility to work in the United States, but they will have a driver's license. Now, California decided to protect undocumented immigrants from retaliation or discrimination. They've made it illegal for an employer to require an employee to provide a driver's license unless it's necessary for the job. So, for example, if they drive, if they're required to drive for their job, then you can, of course, require it. But it is unlawful to discriminate against an employee based on them holding a driver's license that indicates they can't lawfully work in the United States. Now, harassment, discrimination, retaliation are broad terms that cover pretty much every claim, or I say most claims, for wrongful termination. When you terminate an employee, you typically get, two sets of claims. You get wage and hour claims saying they weren't paid correctly, or they weren't given their meal and rest breaks, and then you get a claim that they were wrongfully terminated, and it's usually based on, retaliation, discrimination, or a harassment claim. There's several different claims. These are protected classes that most people are familiar with: race, gender in California, religion, age. Those are all common claims that people, employees will claim that they were fired because of one of those aspects. But there's other claims for harassment, discrimination, retaliation as well, related to action. So, for example, if an employee were to complain about their hours or their working conditions, or they're complaining they're not being paid correctly, or they report harassment, discrimination, and retaliation, and you terminate them for any of those reasons, that also is a protected class and is unlawful. Now, under California law, every employee must have a harassment, discrimination, and retaliation prevention plan. It has to be set forth. This is typically something that you would put in your employee handbook. And starting, I want to say 2 years ago, the law changed and required employers to also provide sexual harassment prevention training to all employees. Previous to that, employers were required to provide it for supervisory employees. So currently the law is for every supervisory employee, every 2 years, they have to have at least 2 hours of sexual harassment training. For all other employees, they have to have at least 1 hour of sexual harassment training. Now, liability for employment claims. Now, most of the stuff we just talked about dealt with, general HR issues to avoid liability. Now, when an employee is terminated is usually when you see a claim for either wrongful termination or wage and hour claims pop up. Employers have to understand and recognize the length of that potential liability and make sure that they take steps to protect themselves. So generally speaking, an employee can bring a employment-related claim within 4 years of filing the lawsuit. So it's important to note that if you terminate an employee a year and a half ago, that doesn't necessarily mean that employee is not going to pop up and all of a sudden file a lawsuit for unpaid wages. So it's important that you generally keep documents for at least 4 years, so that you can defend any claim that is brought. It's also important to note that there's many claims that are representative claims. What that means is an employee can not only sue for their own harm, but they can sue for the harm of other employees. There's various ways to do it. The most common that most people are familiar with are class action lawsuits, in which an employee says, I was harmed in this way and so was all these other employees. And another is what's known as a PAGA claim, or Private Attorney General Act claim, which allows an aggrieved employee to seek penalties on behalf of the state. So it's important to realize that even if you have an employee who has relatively minimal claims, for example, you didn't pay them overtime, but they only worked a few hours of overtime, those minimal claims can turn into very expensive claims when you start factoring in all of the employees you had over the last 4 years and the liability that extends to can be extended based on either a class action lawsuit or a PAGA claim. And it's also important to note that liability is not, in employment law, is not limited to the unpaid amounts. If you don't pay an employee a few hours of wages, the liability just for those wages might be small, but California tacks on a lot of fines and penalties and interest, so small claims can quickly become extremely expensive. For example, the penalty for not having accurate wage statements under PAGA is $250 per employee per violation, or if you've already been cited once, it's $1,000 per employee per violation. So if you're a small employer with, say, 10 employees, and you pay your employees weekly, so there's 52 pay periods, you could be looking at a liability of $130,000 just in penalties based on having an inaccuracy in your pay stubs. So it's important that you take the time to make sure that you're complying with the law to the best possible. Now, we're not going to go into detail about personal successorship liability, but I did want to bring it up because it's something that does affect contractors often. It's important that contractors and all employers know in California that most of the employment laws are actually criminal statutes as well. Generally speaking, you're not going to be prosecuted criminally. It's very rare that would happen, but it's important to know that most of the labor code violations are misdemeanors. Some of them are actually even felonies. So there is the possibility of liability and criminal jail time even for violating employment laws. Again, it's very rare that you would be prosecuted criminally for an employment law violation, but it's important to know that does exist and can happen. But it's also important to know that there are many laws that allow a employee to hold officers, directors, and managing agents liable for employment law violations. So just because you're a corporation and you're protected, based on the limited liability of that, and you think that if there's a big judgment against you, you can just abandon the corporation and start a new company. The reality is that there's many ways in California for an employee to sue the managers or the owners of the companies. So you do want to make sure that your company is complying with wage and hour laws, because you can be held personally liable as the owner. Similarly, there's many laws that deal with successorship liability. Now, successorship liability basically means when a entity such as a corporation ceases operating and closes up shop, but then a new company is started after the fact, if the companies share officers, share offices, share, is really just a successor of the previous company with a different name. There's various laws that allow the employee to go after the successor company to collect on judgments. Again, we're not going to go into detail about all of those here, but it's important that you know that does exist. Now, how to mitigate risks of employment claims. There are several things you can do. First, we typically recommend that employees or employers have arbitration agreements with class action waivers. Now, normally when there's any sort of dispute, but including an employment dispute, the employee can file a lawsuit and pursue the claim in court. Now, most contractors are familiar with arbitration agreements because they have them in their contracts, and it's a common provision that they have. But you can also have similar arbitration agreements with your employees. And one particular advantage you can have in an arbitration agreement is you can have a provision that waives class actions. So that means you could prevent those representative claims where a employer sues on behalf of other similarly situated employees. But it's important to note that you cannot waive PAGA claims through an arbitration agreement. So there is still some representative actions that an employee could bring, even if you do have an arbitration agreement. And generally, arbitration is much cheaper than litigation, so employers benefit from having the agreements. Another thing that we often recommend is severance agreements. Now, when you terminate an employee, and we'll talk about this a little bit more later, but when you terminate an employee, there's no requirement that you pay them any sort of severance. Usually, there's a few exceptions if you have a mass layoff, for example. But you can offer a severance agreement, and basically it's an agreement in exchange for the employee to waive claims. Oftentimes, it's much cheaper to throw a little money at the employee at the time of termination than to defend a lawsuit, even if it's an unmeritorious lawsuit down the road. The third thing we often recommend our clients get is employment practices liability insurance. Now, this is an insurance policy, and it covers liability for claims of wrongful termination, harassment, discrimination, etc. It's important that not all policies are the same, so it's important that you look at what your policy covers and make sure it provides the coverage that you want. But generally speaking, it's important to note that the cost to defend lawsuits are extremely expensive for employers, and typically because you can't recover your attorney's fees in the end, even if an employee brings a meritless claim, you still end up having to spend a lot of money to defend it. So having insurance will allow the insurance company to step in and defend the claim and save you money. Now, other ways to avoid, limit, and mitigate your risks of employment claims is basically actions you can take. First, strictly follow your policies and investigate all complaints. Whenever an employee complains, even if you know the claim, the complaint really has no merit, you want to take the time to interview other employees and complete an investigation. And you want to make sure that any actions you take, for example, if you provide discipline, you follow your policies. This will prevent claims of discrimination because you investigate every claim and you're treating every employee equally. Next thing you want to do is before you terminate an employee, you always want to analyze the risk. And we'll talk about this in more detail in a second, so I won't go into detail here. And the last thing, and this I see too often employers don't do, and I can't stress this enough, is document everything. If you have an employee who's a problem employee, and there's, down the road you decide you want to get rid of the employee because he's a problem employee, and you can go back and recite all the things that he did wrong. The problem you're going to have there is if you don't document it as you go along, the employee and their attorney is going to claim that this was just, made up at the end to justify an unlawful termination. The best way to protect yourself as an employer is anytime you have any issues, document it. If it's a performance issue, write it out, have the employee sign it. Then you have a record that this was a problem. You've addressed it with the employee, and in the end, most claims and most defense of claims that we deal with, we end up having a he said, she said situation where there's a few documents or a few emails that might, support the employee's claim. There's a lot of stuff that should be able to, support the employer's claim, but they fail to keep the records. In the end, it literally is just the employee versus the employer. Unfortunately, juries tend to be sympathetic and side with employees more often than employers. So the biggest bit of advice I can give any employer, but especially contractors, is just document everything and keep the records, again, for at least 4 years. Now, terminate an employee. As I said before, typically when you're going to have a claim pop up, it's going to be after you got rid of the employee. Whether the claim has merit or not, this is, if you take steps when terminating an employee to make sure that you follow the law and you've analyzed the risks, you can minimize the likelihood of a lawsuit down the road. So the first thing you want to ask yourself is the employee an at-will employee? Now, the general rule is all employees are by default an at-will employee, which means you can fire them for any reason or no reason at all. Now, in order to become not an at-will employee, typically you have to have some sort of contract that says you can only be fired for a cause. So again, the default typically is you're at will, but if you have any sort of employment contract or there's a collective bargaining agreement involved, then there might you have to make sure you comply with those requirements and make sure you're firing the employee for a lawful reason that's allowed by the contract or the collective bargaining agreement. But the next issue is you want to analyze, why are you terminating an employee? Now, even though an employee is at will and you can fire them for no reason, typically you don't fire employees for no reason, and a plaintiff's attorney is going to allege a no reason fire termination was really caused because of some protected class. So you want to analyze why are you terminating them, and you also want to make sure that the reason you're terminating them is lawful. Again, we'll go through some of this in a second as well. Next, again, did you follow your policies? Before you terminate the employee, make sure you look at your employee handbook and make sure that you followed whatever procedures you've set forth in that handbook. And if you're firing the employee for violating a policy, for example, you want to make sure that that's the actual policy that you've put forth. Next, when you fire an employee, the law requires you in California to give the final paycheck at the time of termination. Now, if an employee quits without advance notice, you have to pay them within 3 days. But in all other situations, especially in situations where you're terminating the employment as the employer, you have to have the paycheck at the time of termination. The paycheck has to have all wages that have been earned up to that date, including any vacation pay, if they have accrued vacation pay, because that is a vested benefit. Next, severance agreement. We'll talk about this in a little bit more detail in a second as well. You're not required to have a severance agreement, but we do recommend that you do offer a severance agreement because it's typically cheaper to offer a little money to your employee up front to waive their claims than it is to defend the lawsuit. Lastly, you want to make sure you provide all required notices. I'm not going to go in detail about all of them required, but there are certain notices the law requires. There's an unemployment notice. If you provide health benefits, there's a COBRA notice. Typically, your plan will provide this notice, but you have to notify your health plan that you've terminated the employee. So make sure you follow the formalities of terminating an employee. Now, how to terminate an employee? Now, there's no magic words that you have to say to terminate an employee. You just have to inform them that their employment is being terminated. It's not necessary for you to give a reason for termination. However, oftentimes it is beneficial to give a reason for termination if you have a good reason for termination. And the reason for that is if an employee talks to a plaintiff's attorney about their termination, employees and pretty much all plaintiffs tend to tell their attorney the things that they think is beneficial to their claim, and they leave out things that they think are not beneficial to their claim. And one thing that every plaintiff attorney is going to ask is, well, why were you terminated? And if the employer did not give a reason for termination, it's going to be up to the employee and the plaintiff's attorney to start coming up with protected classes that might have been violated. claiming it's because of the person's race or the gender, or because they spoke out against certain things. So if there is a good reason to terminate an employee, if you document that and give the reason up front, it could sometimes prevent an attorney from taking a claim, because it will give them the attorney information to cross-examine their potential client, and they'll realize the risk of taking this case is higher. But I warn you of this. You do want to make sure that you're careful when you state the reasons for termination, because there are many bases for termination that are legal in some aspects, but would be illegal in other aspects. And you don't want to be admitting to terminate an employee for an unlawful reason. And again, we'll talk about this in a little bit more detail in a second. And when you terminate an employee, typically you don't want to do it you want to do it during the workday, and you want to make sure that a supervisor or a manager is doing it. And it's also a good idea just to have a witness as well, in case there's any allegations made later about how the termination occurred. Now, how to avoid post-termination claims. Whenever I get a call from a client asking about, I have an employee, I want to terminate them, these are some of the questions that I go through and ask them to help analyze whether or not the termination is going to be lawful. There's other questions that will come up as well, but these are just some of the big picture items that you might want to think about when you're terminating your employee. First, you got to ask, is an employee physically or mentally disabled? This is important because it is legal to terminate an employee who cannot perform the work that they're, can't perform their job duties because of a physical or mental disability. However, employers do have a duty to accommodate any physical or mental disability if it can be reasonably done. And before you terminate an employee based on a physical or mental disability, you have to go through an interactive process in order to ensure that you've explored any possible reasonable accommodations. So before you terminate an employee with a disability, you want to make sure that you follow those requirements. Next, is the employee pregnant, or did the employee recently give birth? Now, there are leave laws that specifically protect employees who take time off because of pregnancy or to bond with the child. So you want to make sure you're not terminating an employee who requested legitimate leave, and you're unlawfully denying that leave. Same thing, there's other types of leave too that's unrelated to pregnancy leave. In fact, as of January 1st of this year, all employers with 5 or more employees in California must give CFRA leave, which is up to 12 weeks of leave for certain, to care for certain medical conditions of the employee or the employee's family. So you want to make sure that if the employee is asking for a leave, before you terminate them for not showing up to work, you want to make sure that they don't have any job protected leave. You also want to ask if did the employee file any workers' compensation claims? Did the employee complain about any conduct of the employer? Did the employee complain about conduct of other employees? Now, you can't terminate an employee because they've made complaints about or because they filed certain claims. So you want to narrow this down and make sure you're not opening yourself up to a lawsuit based on these types of claims. And lastly, you want to make sure that if you did classify an employee as exempt, before you terminate them, you want to make sure that you're not going to open yourself up to wage and hour claims. Typically, when an employee goes and talks to an attorney, they're going to analyze the case from a wrongful termination perspective. They're also going to look at your general wage and hour practices and say, are there any wage and hour issues? And the reason they do this is wage and hour claims are often easier to prove with records, and they can recover attorney's fees. So it encourages them to actually bring a claim. Now, I'm being told that I'm going way over my time, so I'm going to rush through these last few slides. Severance agreements, again, we talked about it a little bit before. Severance agreements are not required. You do have to give some sort of consideration for a severance agreement. You have to offer something in exchange for them signing it. A severance agreement is just an agreement for the employee, where the employee and the employer agree to waive claims in exchange for some amount of compensation. Generally, you can waive most claims. The one thing you cannot waive is wage claims unless there is a bona fide dispute about the wages. So, for example, if you have a severance agreement and the severance agreement says you've been paid everything that you're owed, and in reality you haven't paid everything that's owed, and there's no real dispute about that, the severance agreement is not going to protect you against wage claims that are subsequently filed. Lastly, when in doubt, we recommend you talk to an attorney. And we have several clients who, before they terminate any employee, they give us a call and say, I plan to terminate this employee. Here's why. Is there anything I have to worry about? And we go through the protected classes that might apply. We look into their wage and hour issues and look at any potential liability, and we can give a recommendation as far as what's the risks of firing this employee. And we can also make sure that you're complying with your own policies and you're not inviting a lawsuit by the way that you're going to go about the termination. So with that said, that's the end of the presentation. If anybody has any questions, I'd be more than happy to answer. So one question is, will we be able to receive a copy of the slides? The answer is yes, they will be on our website, I believe. I don't know if they're already up, but if not, they'll be up shortly after we conclude. Is there a standard training that covers multiple state requirements for managers who manage employees in various states? Possibly. I mean, there are many companies that offer training. I don't know off the top of my head, but a specific company. But I have seen numerous online programs that indicate they cover different states. I don't know the requirements for all different states, so you have to look into it. So the answer is, I know it exists. I just can't point to a specific one for you, unfortunately. The next question is, our timesheet system doesn't have the function to track meal and rest periods. How do you recommend we protect against employees claiming they didn't take a meal or rest period? My recommendation is create a record. Even if your time system doesn't do it, have some sort of other timesheet where they sign in and out for lunch breaks. It's important to have some sort of record, and the reason for that is the law basically says the employer has the duty to keep track of the time, including the meal periods, and if they don't, the employee is not penalized, and they can prove their claim based on a reasonable estimate. And in my experience, every reasonable estimate every employee comes up with is not reasonable at all, and severely overestimates the claim. And the duty then switches to you as the employer to prove the amount that's owed. So I would look into the best way is to have a time clock system that precisely keeps track of the time. And here's one of the issues that comes up often too. We often see time records where the employee clocks in and clocks out using some sort of time system, but then the lunch period happens at the exact time every day from, say, 12 to 12:30. And whenever you see that on a time record, it raises a red flag to say, well, the employee obviously is not leaving exactly at 12 and coming back exactly at 12:30 every day. As a result, it looks like this is a fabricated time record. So the best thing you can do is come up with some system to have them clock in and out for meal periods. Again, if you can't change your time system to do it, just have the employees have a paper time system each day where they have to write down the time they left for lunch and write down the time that they came back, and have them submit that, once a week. And it's also important to note, the law doesn't require you to force employees to take lunch breaks. It only requires you to provide the opportunity. But as a practical matter, a lot of employers now are forcing employees to take the meal breaks because it avoids or helps avoid, frivolous claims of being denied meal periods. If you can show that they actually took the meal period each day, that's easier to prove than to have to prove that you offered it to them and they chose not to take it. Now this typically this comes in the form of the employee alleging that yeah, they said I can take a lunch break, but in reality they didn't give me the time. They forced me to do work and work through the lunch break, or they just gave me so much work that I had to finish it in a day that it just wasn't possible for me to finish it. So hopefully that answers your question. Next. Since AB 51 was signed by Governor Newsom, are arbitration agreements allowed in California? Should you still include them in your handbooks or not? Well, this is actually somewhat of a gray area in the law. And I say it's a gray area. I mean, the law itself is clear as far as California law. The problem is there is the Federal Arbitration Act, which most likely preempts AB 51. So if you want to be, I mean, arbitration agreements are legal. The issue is, can you require the arbitration agreement as a condition of employment? And AB 51 says no. So one way, if you want to, make sure you're in the clear, is instead of requiring arbitration agreements, you can, offer consideration in exchange for signing the agreements. For example, you would offer to pay the employee, $200 if they sign an arbitration agreement. That doesn't conflict with AB 51, and that's a separate agreement to arbitrate that has separate consideration other than employment, and that's one way to make sure that you're in the clear. But our recommendation is for employers generally still to have arbitration agreements, and even if they still require them as a condition of employment, because there's a very good argument, and this hasn't been resolved by courts at this point, so I mean, I can't guarantee that this will be the end result. There's a very good argument that AB 51 is preempted by the Federal Arbitration Act and therefore not enforceable. The next question, if an employee refuses to take the COVID vaccine, can you fire them for failure to take the vaccine? The general answer is yes. There is no specific guidance related to the COVID vaccine, but there has been lawsuits and claims relating to flu vaccines previously, and the general principle that's settled in the law is that an employer can require an employee to take a vaccine, as a condition of employment. However, there's some caveats to that you have to be aware of. So, for example, you still have a duty to accommodate religious beliefs, accommodate disabilities. So if an employee says, I can't take the vaccine because I have a health condition and it's too risky, in that case, you'd have to accommodate them, if possible. A good practice is, if you have a good, if there's a good safety reason for requiring a vaccine, you're okay to require it as long as you accommodate religion and disability issues. Now, generally speaking, as of right now, and again, there's no guidance on this, so it's very difficult to say for sure what a court would do. But COVID generally is considered, a safety issue for everybody. But going to the flu, for example, requiring every employee to get a flu shot one of the issues would be is it necessary for the employment? Now, in certain industries like healthcare, it's common for the employer to require flu shots, and that would certainly be legal. But for other employers where there's very little risk of flu, that wouldn't be the case. COVID is a little bit different because, again, it's everywhere. It's a risk to every employee. There is no specific guidance right now or specific case law that says one way or the other. But I would say, generally speaking, based on the precedents, is you can require your employees to take a COVID vaccine, and you can terminate them if they refuse to, so long as you also accommodate any protected classifications that they have. The next question is, we offer a 3-day sick time and are based in Ventura County. If a project is based in LA, do I need to offer the increased number of days? The general answer is yes. So the LA minimum wage law, which is also what includes the sick pay law, it applies if an employee works 2 or more hours in any given week. And it also requires that the employee work 30 days, for the same employer for at least 30 days. So as a practical matter, the only exception would be if an employee, generally works in Ventura, but has to, once a week, spend an hour in LA, that employee would not be entitled to the extra sick pay. But any employee who works more than 2 hours in any given week is required to be paid the larger sick pay. And the same applies for minimum wage, by the way. So if you have an employee and they're making, Ventura minimum wage or state minimum wage, do you have to pay them minimum wage, LA's minimum wage? And the answer is, yeah. If they work more than 2 hours in any given week, then yes, the higher minimum wage applies. If they work less than 2 hours in any week, then you don't have to pay them the extra minimum wage. I think that's all of the questions. Any other questions? All right, thank you. Again, the PowerPoints will be online, and I also believe this entire webinar will be posted online as well if anyone wants to review. If anybody has any further questions or needs any help with anything, feel free to reach out to us, the Green Law Group. Again, we handle all contractor matters. My specialty, again, or my area of focus really is employment law, but any issues you have, feel free to reach out. Thank you very much.